All right, the final case today is, I'm going to call it Agape or Agape, Motorcoach Retreat versus Brintle. And Mr. Burns, whenever you're ready, we'll hear from you. Is it Agape?
It's Agape.
Agape.
Agape. It's
I think my law clerk had it right.
it's the I believe it's Greek for God's love.
Yeah.
It's the definition.
Yeah.
May it please the court, my name is Hunter Burns, and I'm here on behalf of Agape as well as the Gregsons. We have appealed this case based upon the District Court of Western Virginia's granting of summary judgment for the United States of America and David Vila, as well as the granting of summary judgment in favor of Mr. Bolin and the trustees of the Brintle Revocable Trust, and denying appellant's motion for summary judgment. The basis of our appeal, I have two main reasons that this court should reverse, and it's based upon three separate and distinct issues. Two of them are tied into one of the reasons, and then one follows. The first issue involves the jurisdiction of the Virginia Circuit Courts. The second is defeasibility of title, and the third issue involves the separate easement over private property. First, appellants have an easement over federal land directly to the Blue Ridge Parkway and or the state road, stemming from a 1938 condemnation order from the Carroll County Circuit Court.
Are you stating that as a fact, or is that a contention?
That is our contention.
I thought so.
That is our contention, Your Honor. But we believe that it is based upon.
And you're relying on the marginal notation on the order that was dated probably July 1 or June 30 of 1937.
Yes, the marginal note that you speak of, the handwriting.
That's what you're relying on, the easement, preservation of the easement during the condemnation proceeding.
That is correct, Your Honor.
Now let me just ask you, that was entered, filed on July 2, but from the face of the order, it looks like it was entered probably July 1 or maybe even July 2. The court had said 30 days have passed since May 30, and it entered that order. And it could not have, since all that's typed, it could not have entered the written order until after that, or as at the time it signed it. So the best you can get is a court entry on that order around July 1.
I believe that that's reasonable, Your Honor.
But there was a conveyance to the United States that didn't reserve that easement back in May.
Yes, Your Honor.
Well, it seems to me the United States got it free of the easement.
No, Your Honor, it did not.
There was no easement at that point.
Well, Your Honor, there was an easement at that point because, and this goes to the second issue, which is the defeasibility of title. At that time, as we know,
At what time?
At the time that the United States was conveyed the property.
Right, May 18th, yeah.
The Commonwealth of Virginia, as we know, a basic tenet of real property is you cannot give more than you have.
Right, but you cannot condemn more than stated in the petition for condemnation. That defines the take, does it not, under Virginia law?
Under Virginia law, Your Honor, a court of general jurisdiction, which is the Circuit Court in Carroll County, has jurisdiction over the condemnation proceeding.
Right, but the petition for condemnation, the whole statutory scheme in Virginia is the petition defines the property to be taken. Then it goes to the commissioners. The commissioners review the land taken, the residue of the property, they value the land taken, and the diminution of value to the residue. And the court makes the determination in value. And even back in 1914, the Virginia Supreme Court was saying pretty clearly, without an amendment to the condemnation petition, there is no right to ask for a different estate than that set forth in the petition. So where is there evidence in this case that the petition for condemnation was amended to reflect an easement?
The evidence is specifically in the marginal note.
No, the amendment to the petition for condemnation,
okay.
Not the court's order.
All right, I understand, Your Honor. that ruling from 1914, as well as further case law, says an amendment to the petition or the consent of the parties. Am I accurate with that, Your Honor?
I don't believe so, no. Because
I don't even think the role of the court is to mess with the title. The role of the court is to confirm the value.
Well,
and the court can only confirm the value as assessed by the commissioners, and the commissioners were looking at the fee simple. The commissioners were not looking at the reserved easement. There's nothing in the record that shows that the commissioners valued the property with this easement. Isn't that correct?
That is correct, Your Honor.
Okay, so how can then we find that when the commissioners valued the property and the court passed on the value of the property, that there was any contemplation of the easement? You're saying just the handwritten interlineation without an amendment to the petitioning condemnation and without the condemnation commissioners being given the opportunity to evaluate the property with an easement. How can that be? Well, then the court could just write in the margin whatever it wants, and the process is totally circumvented.
It's not, Your Honor, because by the court of general jurisdiction entering that order, it was subject to appeal at that time.
And it was just the amount. The condemnation takes place pursuant to the petition, and the petition did not show the easement. Under the petition, the title went to Commonwealth without the easement. The Commonwealth conveyed it to the United States on May 18 without the easement. Right?
No, Your Honor, I don't believe that.
This is May 18. Your entry didn't come in until a month and a half later.
I understand, Your Honor, but the statute that controlled says that it is subject to confirmation by the court, the circuit court. Now, I understand.
Just the amount.
Well, Your Honor, I understand.
If somebody wanted to expand title, they'd have to file a separate suit. But the condemnation, the right of condemnation, is determined by the Commonwealth. It defines the take, and then it goes and assesses the value. They put the value in the court. And the court approved the value. But if the title didn't pass at that time to Virginia, way back in May, something's wrong, because then you're saying the United States didn't get title.
That is exactly what I'm saying, Your Honor. And if
how did they not get title? There's a deed in here.
I understand that there's a deed, Your Honor, but that was subject. It was a defeasible title at that point, and it was defeasible.
The United States was not even a party to that proceeding.
Your Honor, they received all that they could receive, and again, all that the Commonwealth could have given them at that time, because the Commonwealth did not have a deed. The Commonwealth did not actually own that property, and the recorded deed has the exact same handwritten note in it. Therefore, the Commonwealth of Virginia, whether you want to admit it or not, as to whether or not they had the authority to do so, at that time, the circuit court, the original condemnation order, the recorded chancery deed, and the recorded deed order all have the exact same handwritten margin in it. I'm sorry, Your Honor.
Where's the recorded deed here?
I believe that it is on page 120. I believe it's on page 141, Your Honor. I hope that's.
Aren't you circumventing the whole statutory scheme? Because the law is pretty clear that the fair market value is determined as of the take, as of the time of the taking. And here you have this so-called easement added way after the taking, after the petition was filed. And so the whole statutory scheme is undermined. And, you know, the Supreme Court of Virginia has been really clear that everything is measured from the time of the taking. I mean, every case of the Supreme Court talks about that.
Yes, Your Honor, I agree. If this were an easy issue, Your Honor, we never would have been here. But Your Honor, the Supreme Court of Virginia has also been clear about the circuit court having jurisdiction over condemnation proceedings. And if it is an error, then there's a proper procedure to go through.
But the circuit court can't say, I mean, I know, the circuit court can't say that you get more land than the Commonwealth put in its petition. The circuit court can affect the valuation. It can disagree with the commissioners. It can, ask for a reevaluation. All those things the circuit court can do, but it can't add or subtract to the land in the condemnation petition.
Your Honor, I'm well aware of your previous job.
But do you have any cases in the Virginia Supreme Court that says that the circuit court of general jurisdiction can add or subtract to the land defined by the petition in condemnation? Not in those words. What I have, Your Honor, is the case law from the Supreme Court along the lines of the Chesapeake and Western Railroad Company and the Washington and Cincinnati St. Louis Railway Company. And that line of cases, Your Honor, it does not say what you are asking me. But the court never did that. The court never added to the land. It never subtracted from the land, did it? Show me a case where the court enlarged the estate or subtracted from the estate that was defined by the petition in condemnation. Your Honor, I do not have that case. And I'll tell you, I think the reason that I don't have that case, Your Honor, is because what we're dealing with here in this case is a collateral attack. It's an interpretation of a court order. Nobody's saying that the circuit court, excuse me one second, and then I'd like to hear your answer. Nobody's saying that that order isn't valid, and nobody's saying that the order doesn't value the property. It's not an attempt to invalidate the order. It's just saying what was the lawful scope of the order. Well, Your Honor, this is an attempt to, I believe, invalidate or to consider void the original condemnation order, because the original condemnation order specifically sets forth the property that was condemned. That is what is a matter of record. But if the role of the court is to value the property as defined in the condemnation petition and as evaluated by the commissioners, both as to the take and as to the residue and damages thereto, then if the court performs another act and decides to take a little bit away, you're saying that that's good for the ages just because the parties didn't appeal it? Yes, Your Honor. I believe that it is. And I believe, again, going back to the United States and what the United States actually received, what they received was the land minus the easement, because the title at the time that it was conveyed was defeasible, subject to the confirmation of the circuit court. And what the circuit court...
Where do you get that? I'm reading the statute, the 1936 statute, and it says, upon the report of the commissioners, title shall passes to the Commonwealth, shall vest in the Commonwealth in fee simple, to such extent as may be prayed for in the petition. That's when the commissioners return it, which I think restricts the court's role to reviewing the valuation if it's appealed. I have... See that? I'm looking under 1969J.
Yes, Your Honor. I do see that. I see my time has expired.
Go ahead.
My answer.
Sure, go ahead.
There are two different...
By the time we're done with real estate, we may be here at 4 or 5 o'clock and put on our eye shades and keep going.
Well, I mentioned to counsel of record earlier, I thought this might be dry compared to Swiss family law and Minnesota defamation law, but I'm glad to see that you're as intrigued as I am. There are two separate statutes. There are two separate statutes, Your Honor. The 1969J, which you've referred to right there, must be read in conjunction with Section 4369, because reading them together, the 4369 says that unless good cause be shown against the commissioner's report, the same shall be confirmed by the court, and further that upon such payment either to the person entitled thereto or into the court and confirmation of the report, the title to the part of the land and to the other property taken for which such compensation is allowed shall be absolutely vested in the company in fee simple. The Keys Court...
Are you getting to the part that helps you now?
Well, yes, Your Honor.
Okay.
The Keys Court held that the condemnation proceedings instituted under 1969 shall be absolutely vested in fee simple only after the report of the commissioners is confirmed by the court. Reading 1969 and 4369 in conjunction, 1969 is silent as to the nature of the title which vests in the Commonwealth. It doesn't say, as Your Honor pointed out, it doesn't say whether it's indefeasible or defeasible title. But 4369 says that absolute title does not transfer until the confirmation by the trial court. Now, I understand Judge Keenan's pointed analysis of whether or not the court had the authority to expand or decrease the fee that was being transferred between the parties. However, it was either void because the circuit court did not confirm it, or it was a valid judgment which includes the easement. And if it's void,
I think that actually what you say is possible, I suppose. But if we really wanted to accommodate both of those statutes, it seems to me the way the Virginia Supreme Court has done so, when there are other cases, is a pretty clear indication that we do exactly what Judge Keenan says. We read it that way. And I don't understand.
I believe that's again, I apologize, but I believe that's basically blue penciling the order that was entered by the circuit court. And I don't believe that is allowed.
It would not be if the order is taken only for the purpose of confirming the amount. Right. And if it's taken for confirming the estate taken, I think you have to be right. But I think if it's taken only for confirming the amount of compensation, then it seems to me both statutes say that the title vested, the section you referred to said title vested absolutely upon the payment of the return of the commissioners.
And confirmation.
Payment, yeah, into the court.
And confirmation.
Yeah. But you're basically, we have to get to go along with you, we have to conclude that the court had the authority to redefine the estate. Is that right?
Well, there's actually one more argument which I haven't even gotten to yet, which hopefully I'll get to when I come back up here. But and that involves the fact that the district court granted summary judgment to all of the defendants and said that for the private defendants, a granting of summary judgment was appropriate because there was no federal easement. And I believe that the two issues can be separately read. And
all right, we'll get you back up here, and you'll get us straight. All right, I guess we have two. Mr. Eckert first.
Your Honor, please. Good morning, Your Honor. I'm Tom Eckert. I'm an assistant U.S. attorney in Roanoke, Virginia. I'm here on behalf of the United States in this matter. And what I'd like
to... They're messing with your property?
Yes, sir. The Blue Ridge, the concept of Blue Ridge Parkway, back in when this order was entered and the deed to the United States was conveyed to property of the United States to construct the Blue Ridge Parkway, there were a lot of easements. That deed, it contains a comprehensive list of many, many easements, a lot of pages of easements, which went with the conveyance to the United States. Conspicuously, however, the easement now alleged by the appellants was not among those easements on that May 8th deed.
His argument, I gather, with respect to the title, that's one of my big hang-ups, and I want to ask him to address this, but basically on May 18, the title was conveyed to the United States without the easement.
Yes, sir.
And his argument is that even after you've gotten that property without easements, somehow that conveyance to the United States, which was not before the court, that conveyance to the United States is subject to defeasance, I guess is the word he's using, which I'm not sure what it means, how they can go when it's conveyed to a third party. Here you have, you start off with the Commonwealth condemning it, and the whole proceedings that we've been arguing about involve how the Commonwealth gets title and what title they get. But then the Commonwealth did convey it to the United States on May 18th without the easement.
Yes, sir.
Now, his argument, I suppose, is the United States can't get any more than the Commonwealth had.
Yes, sir.
But at that point, the Commonwealth conveyed without easement. And the question is, did they have it without easement? They condemned the easement. They condemned everything.
Yes, sir. That was my understanding. As I look at the body of law, the eminent domain scheme in the Code of 1930, they took it without easements. And indeed, on page 92 of the Joint Appendix, where Judge Drake...
Which presumably would mean the easement holder could come in and get compensation too, maybe.
Yes, sir.
But the condemnation itself took the land without easement.
Yes, sir. And indeed, the easement would have had to have been valued by the land commissioners. There were two sets of them. When the Bolins lost their land to condemnation, the first set of land commissioners went out and they set a price.
Didn't give them enough money.
Right. They said, we want more. So Judge Draper, under the statute, appoints a second, which is one of the things he can do, appointed a second set of land commissioners who went out and gave them more money. When they filed their objection to the first land commissioner's report, they never mentioned anything about any easement. There's never in this entire record any mention of any easement whatsoever until you look at the anonymous, interlined, handwritten note that presumably, we don't know, presumably is written by Judge Draper at his direction.
It looks like it was written by Judge Draper on July 1, 1937, or whenever the date is.
Everybody assumes that, Your Honor. But we look at that order, and it's right curious because on page 92, the order says something entirely different. It says at the very bottom, and doth confirm unto the Commonwealth of Virginia, as provided by statute, free and clear of all liens and encumbrances, the fee simple title to all that property belonging to M.M. and Myrtle Bolin and so forth. That's in the typewritten body of the law, which conflicts absolutely with the handwritten interlineated notes. It's the sole basis of the appellant's argument. Never was any easement pled by the Commonwealth or pled by the Bolin's attorney or anything like that. It just kind of appears out of nowhere when in Judge Draper's order.
Well, somebody was standing before him as he had that order and said, don't forget to put in our easement. He says, what you talking about? He says, well, we have an easement. He says, oh.
Well, we don't know that. It may have happened that way in Carroll County in 1938. I don't know.
Was it 38 or 38?
Yes, sir, 38. The Virginia Supreme Court has repeatedly held since before the order entered by Judge Draper that a court cannot enter a decree, judgment, order, or anything else based upon facts not alleged, a right not pleaded, or a claim, a right not pleaded and claimed, no matter how meritorious. And that was in the 1935 case of E.W. Potts Trustee versus Matheson Alkali Works. And then there are a number of other cases even before that with the Virginia Supreme Court. In this case, the easement now claimed was never pled, never alleged, never claimed. It was not part of this litigation.
Okay, let's assume that something was said to Judge Draper that prompted him to enter that marginal order,
right,
reserving an easement in his order.
Right.
What effect does that have on the land that the United States then had in fee simple? His argument is there's a defeasance, and I don't know how that works.
Well, I suppose I defined in my brief the Black's Law Dictionary defeasance. Let me back up for a second, if I might. The fee that's condemned has to be based upon the Highway Commissioner's original petition.
Well, that makes a lot of sense, and he did that, and the money was paid into court,
Right.
and the United States was given title.
Right,
Now, the state proceeding still had to confirm the amounts,
right.
and the judge did that, but in doing that, he adjusted the estate.
He reduced,
He reduced the estate.
yes, sir. I don't think it affected the United States.
Well, now, his argument, I think, he'll make, is that the United States got the title subject to this defeasance practice,
Right.
and therefore, it was going to be bound if it turned out later. But that's sort of strange. There's no finality in deeds then.
Right. You can go on forever. And Judge Turk, I think, recognized that when he said there was only certain things that Judge Draper could do. And the Commonwealth could only be defeased of its title under certain very limited circumstances. And Judge Turk addressed those and said, hey, none of those existed here. And because none of those existed in this particular case, the interlitigated note was exceeded Judge Draper's subject matter jurisdiction. And the defeasance was...
What do you rely on to make that argument?
He went through in some detail, and I outlined it in my brief, in both the general condemnation statutes and in the specific 1969J statute that dealt with the highway commissioner's condemnation process, the entire eminent domain scheme, that there were only certain circumstances, one of which was that the highway commissioner decided that he didn't want the land, or the government or the entity decided did not want the land in question prior to the vesting of any interest, and thus could withdraw its condemnation. The other thing would be if the governmental entity never paid the money into the clerk of court. And Judge Turk mentioned, he said, then the title was subject to disfeasance. It seems to me that I argued in my brief, then what we have here is an indefeasible absolute title that the Commonwealth got because none of those statutory bases for disfeasance ever existed. I think the court was absolutely right, the district court, when it ruled that way. And that together with the fact that no easement was ever pled. Nobody thought they had an easement here. The Bolins didn't even think they had an easement here, and their successors in interest didn't either, because they applied for special use permits from the National Park Service twice, at least twice.
Their
maybe it was.
successors in interest
Yes.
did, but the Bolins themselves did not.
Right. They did not. Their successors in interest did, children or grandchildren, something like that. They applied twice to get the driveway, permission to build a driveway that's the basis of the easement, or that is the easement that's now being sought by the appellants. They certainly didn't think they had an easement. If they did think it, they wouldn't have gone through the special use permit process with the Park Service. And we put those SUPs, marked them as part of the joint appendix in this case. And the court can see the reason that they were needed was because they were cut off when the Blue Ridge Parkway was built. The Commonwealth, rerouted a state route and basically cut the Bowen successors off from entry onto the state road. And the roads have been moved since then and so forth. But that's essentially our position, Your Honor. And thank you very much.
While we hear from your colleague, he's going to probably argue with you something differently.
He probably.
Mr. Cardell.
Thank you, Your Honor.
Good morning. May it please the court, I'm Alan Caudle. I represent the individual defendants, the Brintle Trust, which is Thomas Brintle's widow and 2 children, and Tim Boland, who I think incidentally is the grandchild of M.M. Boland, the owner of the land when all this mess started. You have put me in a position where I feel like it's dangerous for me to argue very much about the central part of the case. We do agree with your comments, and you have expressed very well our argument that the circuit court only fixes damages. The commissioner determines what to take. And so when you consult the petition, you see that he took everything. and the interlineation has no effect because that's just not within the judge's purview. It's not a part of his job. I will add one factor. To the extent this is a real estate case, we are concerned with the deeds, and the deeds do matter. You've already pointed out the deed to the Commonwealth of Virginia, from the Commonwealth of Virginia to the United States had already been recorded. But I will note that if you take time to examine other deeds in the record, you'll see that the deed from M.M. Boland did not attempt to convey this easement. It talks about an easement, but not this easement. It doesn't talk about an easement across the parkway. You trace those deeds down 3 or 4 steps, and the 2005 deed to Agape, the current plaintiff, also does not attempt to convey this deed. Agape has to rely only on having come up with this interlineation and then claim it's an unwritten appurtenance to the property to trace it through the chain of title. It's not just a coincidence that it doesn't appear in the Commonwealth's deed to the United States. It does not appear in the first deed M.M. Boland made. It does not appear in any of the deeds after it, and that's simply because it doesn't exist. I would ask for the other part of my argument that the court consider...
Under this procedure,
Yes,
is
sir.
there ever a deed recorded in favor of the Commonwealth? Or does the Commonwealth, in this case, the Commonwealth conveyed it right out to the United States?
I don't believe there's an intervening deed.
There's not an intervening recorded deed?
The arrangement between the federal government, who endeavored to construct the parkway, and the states through which it passed was that the states would exercise the condemnation power to condemn the land and then convey it to the federal government, and that is what happened. So the state acquired, well, in this case, the state only acquired a condemnation order. However, if we examine the lands conveyed by the Commonwealth to the United States, many of those lands were acquired agreeably with the landowners. They made an offer and the landowner agreed to sell, and therefore the Commonwealth acquired many deeds, just none that affect this case. I would like to address the second argument that Mr. Burns has alluded to, which is that the easement across Brintle lands and Boland lands has some viability even if they can't cross the federal government property to the parkway. We strenuously resist
Was this argument made
that.
below? Was this argument made below?
No, that's the principal part of my argument is you can't change the location you're claiming on appeal. They made an election. They have told the court where they asked to go, and I will supply you with that information. In the complaint, particularly at the Joint Appendix, page 31, they say many preamble-type paragraphs, but when they get to what they ask for the easement across the parkway land at that location. And I will direct your attention to the Joint Appendix at page 45. That is by far the most useful diagram in the Joint Appendix.
It shows a sliver of land in between there.
Right.
It does, and the thing that...
It's a little bit confusing because the one at 127 or 128 is it? Oh.
It's actually on a
It's
little bit different
128.
scale and for the parkway purposes for the special use permit, but they're both accurate in that they both depict that the Bolands do not own any property joining the public road. There is a tiny sliver of land that goes all the way across our road frontage. So
Right.
you can't cross Brintle and then cross us and get to the road. If you can't cross the parkway, you can't get to the road. And so under the doctrine of the Virginia Supreme Court in Atkinson versus Wexford and Associates, if you have an easement across 2 or 3 property owners, if you can't reach your ultimate destination, you can't cross the first 2 and go back. You know, it's just really a statement of common sense. If you're, in that case, they were trying to cross 10 different lots to get to a cemetery. But since they couldn't cross the last couple of lots, they also had no easement across the first 8. You can't go part way if you can't get all the way. So in this case, if the plaintiffs fail to cross the parkway, they also cannot cross Brintle and Boland. And we would ask that the court sustain the summary judgment granted by the district court.
All right, thank you.
Thank you.
All right, Mr. Burns, clean it up.
feel like there's so many questions and so little time. If I may, I'd like to address the state, the private individuals, what we have termed the Bolin easement and the Brintle easement, which were separate from the federal easement across
Where did you make that argument?
the Blue Ridge Parkway. Well, I was quickly flipping to the joint appendix to page 31 to see what he was referring to. This argument has been made all along as far as the deeds that were subject to the federal court below, the district court. The deeds that were given to the court and the relief that was sought was a determination of what exactly rights appellants, Agape and the Gregsons, had over both the Brintle, the Bolin, and the federal property. The deeds that were attached and
I'm guessing I'm asking for the argument against the private defendants separate and apart from any right you have against the federal government. Where is that argument made?
Well, Your Honor, that argument was made in conjunction with the rights across the federal property.
But it was always in conjunction. You never made a free-floating argument against the private defendants, that you had some right to go through their property even if you didn't have a right from the federal government.
Well,
right?
and it's not necessary, Your Honor, because...
Well, I understand your argument it's not necessary, but did you ever make that argument?
No, not that we had rights over Brintle and Bolin, but not the federal. Because at the same time, we would like it over the federal as well.
You made the argument you had it against all three parties.
Correct.
But did you ever say, even if we don't have a right against the federal government, we have a right against these two private parties, and that gets us home?
Well, yes, by submitting the deeds which show that it went to State Road 778, regardless of, and if you look at...
Where is that? I don't see that.
I don't see that either.
I'm looking at page 45.
Page 45. I can show you by map specifically what it is, and it's looking at page 128.
Well, look at 45. I know it's 128. It's a little harder to read.
All right. Well, I'll show you why in just a second. Let me look at flip it the correct because 45 does not show the state road as it existed at that time, and 128. I know that it's blown up and you lose some of the better visual from looking at it afar, but 128 shows you. If you look down at the box on the right side, it says Route 778 as shown on plat of map acquired for the Blue Ridge Parkway, sheet 14 of 26, dated May 13, 1938. Well, that's if you see that road was in that place in 1938, and the deeds that were acquired by the appellants date back to that time, and you can see State Road 778 actually does touch the Bolin property away from the federal lands. And it is possible to access the state road as it was then without the federal, without...
Let's assume you're right. What is it, what are we to conclude now that you look at map 45 and
where the road actually...
And you can't get to 778.
Oh, yeah, 770, it's moved quite a bit.
Yeah.
But what you are to
I mean, today you would have to go across federal property.
And I believe that the only fair thing to do at that time would be to grant them access either across the federal property, even a smaller portion of the federal property, to access the new state road as it stands now, because it moved about 20 feet or so south, and they should either be granted a special use permit across that property to access it across the Brintles, the Bolins, and then across the federal property.
The only way you get that is by making a claim as of 1938 to apply now to conditions in 2013.
Well, and that's why we're asking the court for declaratory judgment on declaratory action as to what our rights were as to the title, because the title as it was conveyed in 1938, 1950, and all the subsequent deeds that occurred with the subdivision, because again, in 1938, there was just one big piece of property. It was the Bolins.
I know, but all the various interests in 1938 are set out by metes and bounds and stakes and so forth, and the United States recorded its special warranty deed, or its warranty deed, with a bunch of easements, but did not include yours.
Well, and Your Honor, that goes back to your ultimate question, which is, what did the United States get when it received its deed from the Commonwealth of Virginia? And they thought, their deed does not have the easement on it. There's no reason they would have recorded it in their list, because they thought...
the United States now conveys it to 16 other people, developers, and the developers convey it to the Indians for a reservation. How long do we keep undoing deeds based on an argument that there was an error in the United States, or you call it disfeasance?
Defeasible title. And Your Honor...
Defeasible or dis?
D-E-F.
Defeasible. Okay.
The defeasible title. And Your Honor, to answer your question that you had about defeasible title,
right.
Specifically in Virginia, it has been defined by the Supreme Court in Home Insurance Company of New York versus Dallas, a 1965 case, as well as Commonwealth Transportation Commissioner versus Klotz, a 1993 case, and Keys versus Shirley, a 1929 case. And it says that defeasible title is one that is liable to be annulled or made void, and defeasible title was subject to defeasance, and other steps were necessary before it could ripen into an absolute and indefeasible title, which just means it's subject to something that's going to happen later. And by statute, specifically something did have to happen. And that something was, it had to be confirmed by the court. And again, I understand Judge Keene's and probably all of yours, which is the only thing they were confirming was the monetary award. And again, I humbly disagree.
Does the Supreme Court take the position that the court did not have authority to redefine the estate when confirming condemnation amount? It appoints commissioners.
It does.
And then its role is not to make the commissioner's decision, it's just to approve it.
Well,
and the question is, when it's approving the commissioner's report, and of course in this case the commissioner's report didn't have the easement in it, does it have authority to reconstitute the estate?
Your Honor, I believe that it does, and I base that belief...
That's really sort of at the core of this, isn't it?
I believe it is, Your Honor. And I believe that in our circuit courts in the state of Virginia are courts of general jurisdiction. And if Judge Draper did not have the authority to enter the order that he entered, then it is subject to attack on appeal. Or his order is void. And that means his whole order is void. You don't take out a portion of the order. You don't say, well, we don't like this part.
So what if we just strike down the whole order collaterally and see he didn't have authority?
Then the United States doesn't have...
We're a federal court. We're not going to mess with that state.
Well, then the United States doesn't own that property. I mean,
are we ever going to come to rest?
And that's where we go back to, which is why I don't believe that the district court's ruling in this case was correct. Because I believe, based upon his logic, based upon the district court's logic, I believe that you would have to determine that 1938 condemnation order as void, which means that the Commonwealth of Virginia never received that property, which means the United States of America did not receive that property. It's much easier to just say, we have that easement. I thank you. I thank you for your time.
If it is an either-or question.
Thank you.
Thank you, Mr. Burns. We'll come down and greet counsel. We'll first adjourn for the day.
This honorable court stands adjourned until tomorrow morning at 9 o'clock. God save the United States and this honorable court.